Hi everybody, welcome or welcome back. This is another in the 10-minute tip series of recorded programs for credit and collection professionals. This one is titled Antitrust Laws and Their Impact on the Credit Department. My name is Michael Dennis. Let's go ahead and jump in. Introduction. In America, antitrust laws make certain business practices unlawful. More specifically, practices that could hurt or harm consumers and customers, with specific actions that result in higher prices, lower quality, or fewer goods and services. State and federal antitrust laws affect specific day-to-day credit decision-making actions and business activities in the credit department. In America, state and federal courts have repeatedly held that a creditor company has the right to extend credit or to refuse to extend credit to a customer or to an applicant, provided that the credit decision they make is being made unilaterally and not in coordination with other creditors, in particular not in coordination with competitor companies. What this means is that any agreement, either express or implied, related to the idea of making credit decisions in concert with another entity may be in violation of the applicable antitrust law or laws. In America, federal antitrust laws are enforced by two different entities. The first is the U.S. Department of Justice and its Antitrust Division, and the other is the Federal Trade Commission. As it relates to the U.S. Justice Department, their antitrust enforcement involves either civil actions, lawsuits, or alternatively criminal cases, and those, of course, would be tried in federal court. The Federal Trade Commission, on the other hand, enforces federal statutes addressing antitrust by bringing civil action against individuals and companies either in federal court or before the agency itself. This is the rationale for the existence of antitrust laws in the U.S. Point number one, free and open markets are the foundation for the strength of the U.S. economy and for the growth of the U.S. economy. Number two, aggressive competition among sellers in an open marketplace results in important benefits for customers and consumers. Those include lower prices, higher quality products, more choices, and more fundamentally, more innovation in the marketplace. There are many goals in connection with development of federal antitrust laws. These are some of the most important goals or objectives of these laws. Number one, to prevent price fixing. Number two, to protect the public from unfair business practices. To help reduce prices to consumers and customers. To prevent what is called the unlawful restraint of trade, to prevent agreements between competitors to jointly increase prices or to jointly reduce output, and to improve marketplace efficiency. Federal antitrust laws. Pricing of products and services, as well as payment terms, are, in fact, subject to U.S. antitrust laws. Please make no mistake, as a credit pro, recognize that the payment terms that we offer to customers are an element of the price that customers pay. Let me give you an illustration. Let's assume you have only two customers. They're both in competition with each other. For customer number one, you offer net 30-day payment terms. And for customer number two, you offer net 90-day payment terms. Irrespective of any other facts and factors, what has happened is you've given customer two a competitive advantage. And more than that, you've given them a price advantage. And you might be asking why. What if we charge the exact same amount on that invoice for customer one and customer number two? I think we all recognize that there is a time value of money, and that customer number two, by having additional time to pay the invoice, specifically net 90 terms, has a price advantage over customer number one that must pay invoices in 30-day terms. So terms are an element of price because they have an impact on the net amount ultimately the customer pays, or the net amount the delivery, the product, costs them. So payment terms are an element of price, and so are discounts. Same customer, same two customers, only this time the difference is one customer has payment terms of net 30 days and the other customer has terms of 2% 30, net 31, which means it's a cash discount for early payment, and they get, in that scenario, a 2% pricing advantage over their competitor, Company 1, which does not receive the discount. What about rebates? It's the same concept. Let's assume you offer customer number 1 a 5% annual rebate on net sales, and you offer customer 2 an 8% rebate on net sales because they're better negotiators. You've given a 3% price advantage to customer number 2 because they get an 8% rebate instead of the 5% that customer number 1 gets. The same would apply to allowances. Allowances as an example for damaged in transit shipments. Let's assume that customer number 1 gets a 2% allowance and customer number 2 gets a 6% allowance. Obviously, customer number 2 has a price advantage because they have a greater allowance on shipments that are made to them. Even if the price listed on the invoice for the product is the same, the allowance results in a lower price being paid by customer number 2. Agreements and collusion. I guess it's possible that two companies in competition with each other could enter into a formal written contract in which they agree to violate antitrust laws. I think it's unlikely, but it's possible. But the point is that it doesn't need to be in writing to be a violation of the applicable antitrust law. Competitors can reach agreements that are never put into writing, never in an email, never in a contract, never in a memo, never in a text message. There is no writing in support of this tacit agreement or gentleman's agreement or handshake agreement that the parties have reached that in some way violates one of the applicable antitrust laws. When the government investigates an antitrust violation, what they often do not find is any form of written agreement, but nevertheless prosecutions occur. How do they occur? Well, they occur based on an analysis of the actions of the parties, and specifically, prosecution occurs when the actions demonstrate collusion. Now, it's possible that the government can even prove competitors' actions were violations of the law, even without any discussion and even without any contact between the two companies. Often, the process goes something like this. They mimic each other. Company A announces a price increase of 5% on January 3rd, and Company B increases prices by 5% on January 4th. And then 3 months later, there's another price increase, and Company B goes first this time, and they increase prices by 4%, and wouldn't you know it, Company A increases prices the next day by 4%. So the government looks at the fact pattern, and it says that is not a coincidence. That is the companies tacitly agreeing that they are going to fix prices by automatically changing their prices to meet or match what a competitor company has announced. So how does the government prove collusion? How do they prove that there is some tacit agreement? And the answer is based on circumstantial evidence for which a reasonable person could reasonably infer or conclude that there was an agreement between the parties to act in tandem. Interactions between creditors. It's clear that creditor companies, including companies that compete directly with each other, sometimes interact, and that they need to interact. There's nothing inherently problematic or unlawful in doing so. Often, in fact, competitors, direct competitors, belong to the same industry credit group or industry credit groups, which means they interact at group meetings and online, they share information in reports that each other sees, etc. The exchange of credit information. As far back as 1925, the federal courts determined that business creditors are in fact permitted to exchange credit information, notwithstanding applicable antitrust laws. However, when this exchange occurs, it may give rise to the appearance of collusion, and that appearance of collusion may give rise to a claim of an antitrust violation, and perhaps even an investigation into that claim of some form of antitrust violation. To reduce the risk, be sure that you only exchange or provide factual, historical credit information. And in addition, under no circumstances would you ever allow, permit, or participate in joint decisions or joint plans or joint actions with any other creditor for any reason. In addition, there's a pretty easy way to try to avoid the appearance of impropriety as it relates to the exchange of credit information. And what is that idea? The idea is that credit references should only be provided in writing. Why? So that there's objective evidence of how the creditor company responded to the inquiry that they received. The idea of only providing written responses will help avoid any potential temptation to offer extraneous information, such as, for example, a rating or a recommendation about a customer or an applicant, or simply any process that might stray in some way from providing only factual historical information. Here are some basic guidance for business-to-business credit pros. Avoid discussions of any unified action with your company's competitors, or for that matter with any other creditor company. This would include any agreement about actions or plans with respect to things like prices, payment terms, discounts, or territories. This would also include agreements to take action or agreements not to take action with respect to the status of an account, customer, applicant, etc. In addition, it's essential that we maintain records of the rationale for the credit decisions that we make. Advice for creditors. Please be aware that conduct that is clearly a violation of one of the more important antitrust laws, the Sherman Act, includes bid rigging, customer allocation, market allocation, capacity coordination, and price fixing, which includes agreeing on prices or credit terms or other terms and conditions of sale, including cash discounts, price discounts, rebates, and allowances, to name only a few. Well, thank you for your time and attention. I do hope that you found this program to be interesting and informative. By the way, if you're interested in listening to the entire 1-hour on-demand program on this topic, please contact my sponsor, the Wisconsin Credit Association, for information about that program and other programs in the on-demand library. Thank you. Be safe. Take care. Bye.